What happens when you leave things out of your divorce decree or your child custody order? Well, it's like it doesn't exist, but it does, and it's something that needs to be dealt with. So let's talk about it. I'm Kate Bim, a family lawyer in Montgomery County, Texas. Remember, I'm a lawyer, not your lawyer. This is just for public information purposes. Every once in a while, I'll have somebody come into my office for a consultation, and they got divorced 5 years ago. And the wife was pregnant and they had a child together, but they didn't leave it in the divorce decree, or they just ignored the fact that they had kids all together. Eek, that freaks me out. Like, why would you do that? But anyway, or they have a house together that they left out of the divorce decree, or there was a retirement account that wasn't mentioned at all. What do we do? Well, when it comes to the kid stuff, you're likely going to have to open a suit affecting the parent-child relationship, or SAPSR, to have the issues like conservatorship, possession and access, and child support addressed so that you have a final court order that's binding and enforceable as it relates to the children. When it comes to the property division, the court has the authority to do what's called a post-divorce division of assets. And so you're likely going to need to bring a second lawsuit in order to convince the court that you owned this property at the time that you were married and that it wasn't disposed of in the divorce. Now, why do people do this? Why would you do this? Well, as a divorce lawyer, of course, I'm just kind of like, I don't know why. It's stupid and it's likely to be more costly. But in the circumstances that I've encountered it in, usually why people make the choice, especially in the property division, to leave things out is because their spouse has convinced them that they'll have some sort of like side deal on how to get things done. And that if they go along with the side deal on how to get things done, they'll have a better outcome. It never works that way. And that's why they're in my office, because the side deal didn't pan out. And so they're going to have to spend more money in order to get this asset divided in such a way to get themselves off of a mortgage or to get their fair share of a retirement account. And so it's really of critical importance that you do things the right way when you are filing for divorce and having a child custody case. And in the child custody circumstances, for instance, let's say that your co-parent says, I'll pay you $1,000 a month so long as you don't put child support in the order. And then they stop paying. What do? You can't enforce that agreement. You need a court order in order for your child custody agreement and the child support to be enforceable by a court. So you're going to have to deal with it eventually. You might as well deal with it as part of the original suit. Again, I'm Kate Bim, family lawyer in Montgomery County, Texas. I'm a lawyer, not your lawyer. This is just for public information purposes. Good luck in court.